Hi, how you doing? I'm going to explain all about music copyrights. So if you're an artist who's writing and recording your own music, then you really do need to understand the basics of this. We've worked with thousands of artists, emerging and independent artists, and we tend to find that most of them don't know this information, which does lead to various agreements and splits and some questionable contract clauses that people are signing and agreeing to out there. So let's try and get that sorted. So the first thing to know is what music copyrights actually are. So let's just look at the songwriting side of it first. If you write your own original song, then you've created a copyright. There's actually two parts to it that exist in that copyright. One's called the literary work, which is for the lyrics, and one is the musical composition, which is for the underlying music itself. Together combined, that is your song copyright. These song copyrights are often referred to as the composition in legal contracts, and you may also hear them referred to as the publishing rights. And if you've co-written a song, then generally speaking, you will equally split the song copyright between the writers of the song. Then if you record an original sound recording, you have created another separate copyright for the sound recording only. This has nothing to do with the underlying song. And this sound recording is often referred to as the master rights in contracts. So if you write your own song and then record it, you will end up owning two copyrights, one for the song and one for the sound recording. This also means that if you recorded a cover version of somebody else's song, for example, you will own the copyright for the sound recording, but the original writer of the song will still own the copyright for the song. So it can be confusing if you're an artist who writes and records your own songs, but essentially you have created and own two completely separate copyrights, one for the song and one for the recording of the song. And these copyrights also have two separate sets of royalties, which we'll come to a bit later. So how is it that you actually come to own these copyrights? So you've written your songs and made your recordings. How is it you own the copyrights? Well, basically, let's look at the song first. Once you've written the song, and once that exists, once you've written it down, or maybe done a rough demo of it, then the copyright for that song exists just by the fact that you've created it. And you are the automatic owner of that as you are the creator. With the sound recording, it's very similar. Once the sound recording exists, then you are the automatic owner of the copyright to that sound recording. Now, there is a slight difference with the sound recording. So if you're using a producer, then obviously the producer is the one that's making the recording. Technically, they own the copyright on that recording, and usually there's an agreement with a producer as part of the hiring agreement that you'd have that they would assign the copyright to you once the deal has all been done. Also be careful if you've got a record label that's paying for your recordings to be made. Often they may therefore think that, well, we're paying for the recording, so we will own the copyrights on the recording. So generally speaking, whoever's paying for it to be done will own the copyright. But assuming that you're an independent artist, you're making your own recordings, you will therefore own the copyright to the recording. Now, these copyrights that you own will give you protection for different periods of time. So you automatically own them because you're the creator of them, the song copyright and the recording copyrights. But with regards to the song copyright, you are automatically the owner of that copyright for your whole lifetime plus 70 years. And with regards to the sound recording, it is 70 years from the first release. Okay, so that's the automatic protection and ownership, if you like, that you get for that copyright. So now you have two copyrights that you own because you created them. The next thing that people tend to ask is, do you need to prove this in some way? How do you prove that you're the owner? So in the UK and in Europe, most of Europe, you don't really need to register it anywhere. So long as it exists and there's some way that you can show that you were the creator of it. So it could be a demo that exists on your hard drive, or you've emailed it to yourself, or you put it up on a website. These kinds of things, you are the automatic owner. In other countries, that is not necessarily the case. So for in the US, for example, you are advised to register your songs and your recordings with the Copyright Office. So that's slightly different. So do check with your country and your territory what is advised for you to actually prove copyright ownership. But in the UK and Europe, generally speaking, so long as it exists and you can show that roughly the date that it existed from and that you're the creator, that is good enough. Now let's look at what copyright ownership actually gives you. Essentially, what it does is it provides you with automatic protections from anybody else using your copyrighted property. Quite literally, nobody can copy it. But real life examples mean that nobody could distribute it, record it, reproduce it, perform it, broadcast it, sample it, alter it, and so on, all these kinds of things. Okay, so no one can do those things without your permission. But the thing to understand is that all of these rights that exist under the protection of your main copyright are often bundled together in packages of related rights. And these are called other names, such as mechanical rights, neighbouring rights, performing rights, these kinds of things. So this means you could own the copyrights to your songs and recordings and then grant permissions to other people for a specific right or for a use of a package of rights, which they can then try and help you make some money from these copyrights. Clearly, you want people to use your copyrights in some way or another because that's the only way you're going to make any money. For example, if you own the copyright to your sound recordings, you can grant permissions to a label to allow them to do certain things which will help them then distribute and market, promote and collect royalties for you on your sound recordings. Similarly with your songs, you can grant permissions to publishers to do the same sort of things with your songs. In addition to this, there are also performing rights organisations or PROs. So you may have heard of organisations such as PRS, PPL, Sound Exchange in the US, these kinds of organisations. And they collect royalties on the public performance of your copyrighted songs or recordings. So there's a whole world of royalty collection here which you can plug yourself into. If you have a label or a publisher, they will have a direct relationship with these organisations, but you don't need a publisher or a label. You can actually collect this money yourself directly too. Now, generally, the way that you grant permission to labels, publishers, PROs and distributors is through something called a licence. So you can think of a licence as kind of a short-term loan of some of the rights that exist within your main copyright. Usually with labels and publishers, you will grant them some kind of an exclusive licence which will give them some control over your copyright for an agreed short period of time. Now, there is another type of copyright request that you may see in some contracts, especially with larger publishers and labels, or perhaps if a label has funded your recordings for you, they may expect this, and that's called assignment. So if you assign your copyright to somebody else, that is a complete transfer of ownership of the copyright to them. Okay, you are handing over all the rights that exist within that song or recording to that third party, and you will no longer have any other right to it whatsoever. They can do what they want. So unless it's specified in the contract that that's only for a limited period of time, this transfer of ownership, the assignment, is permanent. Okay, it's gone from you forever. So generally speaking, if you're an independent artist, you want to only be thinking about licensing your rights to third parties, okay, to labels and publishers and so on, okay. Try to avoid assignment if you can. I would certainly say that if you ever come across a contract where they're asking you to assign your rights to them, you definitely need to get a music lawyer to help you with this. Okay, that's quite a big thing to be doing, is to assign in your songs and your recordings to other people. I hope that's given you an overview of what music copyrights are all about and an idea of what's going on in the music contracts that you're going to see. Now, this is not advice for you on any specific contract. This is just for information purposes, really, so to help you be informed and to help you make better decisions. Clearly, I advise that you seek a proper music lawyer with anything that you are not fully understanding of. Okay, so just be careful what it is that you're signing out there. All the best with it, and we'll see you next time.